Alrighty, good morning, everyone. Thank you for joining us today. My name is Ezra. I'm going to be your host today. Today we're having a very great presentation on fair housing for service providers, led by Laura Dobbs and Steve Fishback from VPLC. As you just noticed, I pressed record. This is being recorded. It will be uploaded to our YouTube channel at a later date, either later this week or early next week. I will be sure to send that link to everyone who registered for this today. So you will have access to that along with a PDF version of the slides. For those who are attending right now live, I will also upload the slides into the chat so you can follow along if you'd like by downloading those slides, or you can just simply watch as the presenters share their screens. Other than that, if you have any questions, any type of technical issues, please do send them to me in the chat. I'm always happy to help. And of course, if you have any questions for our presenters today, please do put those in the chat as well. We will be sure to answer those before our time is up today. But enough from me. I'm going to now turn it over to Laura and Steve. Thank you both very much for being here today.
Hi, everyone. My name is Laura Dobbs. I'm a housing attorney with the Virginia Poppy Law Center. Today, we're going to go over just some basics of fair housing, including all the elements. I think it's important to understand each piece so that when you're working with people, whether it's if you're a teacher working with children who may be having issues, or you're a medical professional and you have a client that's having housing issues, just so if you hear stuff from them in issue spot, you will know what to do with that information and see like, oh, there might be a fair housing violation here, and here's what you can do about it. So first, we'll go over some of those basic elements of what is required to have a fair housing violation and like what fair housing protects. And then we'll go into some specifics on source of funds protections, which are Virginia state protections that we have in our Fair Housing Act that was passed a couple of years ago. And then Steve's going to cover some of the common issues that service providers might run into with their patients. And then lastly, if you have a person who has potential fair housing violations, what do you do about it? How do you enforce those fair housing rights? And I'll kick it off to Steve to give a basic overview of what is fair housing.
That's better. Hi, Steve Fishback. I'm the litigation director here at the Poverty Law Center. So I'm going to talk a little bit, just very basically, about the Fair Housing Act, and then we're going to get deeper and deeper into the weeds as we go through the presentation. So there are both a federal law and a Virginia law that bans discrimination in housing. The people who are covered by the laws differ slightly, and we will go into that. But basically, almost everyone is protected against discrimination in housing. Next slide. So in the way that we're going to go through this is talking about the four elements of who's covered by the law and what the law entails. So fair housing laws deal with a housing transaction where it's illegal to discriminate against people because of their membership in a protected class. So now as we go through this, we're going to like break down those four elements.
So the first is, what is a housing transaction? This covers a whole bunch of different things, from renting or buying a home, which I think is what people will typically think of when they hear housing transaction. But it also applies to if you're trying to get a mortgage, if someone is seeking housing assistance, other community development activities, such as if your locality has planned destruction or redevelopment of housing units. Zoning decisions can affect fair housing, code enforcement activities, and the broad category of other housing related activities. So it's not just renting and buying, it extends to whole slew of other things. And the type of properties that are covered extend beyond what the Virginia Residential Landlord Tenant Act covers. It, of course, includes apartments, houses and condos, mobile homes, but it also includes shelters, nursing homes, group homes, even vacant land. Of course, that can go into zoning. So it's pretty broad of what type of properties are covered. And there are a few exemptions that you probably won't come across, but they're just helpful to be aware of. The first is if someone is selling a single family home and they're not using a real estate broker and they're not advertising discrimination. So say Uncle Joe is going to sell his property to his niece. They're not using a real estate. He's not listing the house for sale. That sale would be exempt from fair housing. Additionally, if it's an owner occupied building with 4 or fewer units. And then when it comes to housing for older persons, as you'll see in a couple slides, elderliness is a protected class here in Virginia. If it's a community intended for older people, they're allowed to limit that occupancy to people who are 55 and older, at least requiring at least one occupant to be 55 or older. And there are a few exceptions for religious organizations, but those are pretty narrow exceptions.
So what does discrimination entail? These are some various practices that constitute unlawful discrimination, and discrimination just generally is the less favorable treatment of a person or a group of people because of certain characteristics of those people. So the type of practices that are covered as that are instances of discrimination are refusal to rent or sell or to otherwise make the housing unavailable. That's actually a very, very broad provision, and we'll come back to that. If there are different terms and conditions of either the rental or sale of housing, if there are actual discriminatory statements made by a seller or a landlord, that too would constitute discrimination. Misrepresenting availability of apartments, like, oh, we don't have any apartments available now, even though they're advertising, for example. Blockbusting, that's actually right now it's more like reverse blockbusting, I think is more of a problem. Blockbusting was a practice in the 1960s and even 1970s where real estate agents would go around to intimidate white people from selling their homes, into selling their homes based on representations that other people are moving in, or people of other races or ethnicity. That's what blockbusting refers to. And interference or coercion or retaliation, which we're also going to get into, is another form of discrimination. Next slide. So here, again, more specific examples, like requiring a family to pay a higher security deposit because they have children, refusing to rent to someone because they're Muslim, real estate, companies trying to convince people to sell their homes at a lower price. Again, this is inciting fears about immigrants moving into the area. This is a form of blockbusting. And lying and telling an applicant with a voucher that there are no apartments available for rent.
So the next element is because of, that discrimination has to be due to a certain characteristic. And this can take different forms. It could be intentional discrimination, i.e. purposely treating certain people less favorably. Or it could be seemingly neutral, but have a disparate impact on a certain class of people. So, if a provider has a policy or practice that has an unjustified discriminatory effect, even if that provider had no intent to discriminate, it could be a violation of the Fair Housing Act. And then Reasonable accommodation or modification is a little bit different, but if the property owner or the landlord refuses to make a change to a policy, or which would be an accommodation, or alter the physical environment, which would be a modification, that would make the housing accessible for someone with disability, that would be a violation of fair housing.
So these are the various protected classes that are covered by both the Virginia Fair Housing Act and the Federal Fair Housing Act. So on the left side are all the protected classes under the Federal Fair Housing Act, and actually number 10, familial status, is also covered under the Federal Fair Housing Act. The other protected classes in green, again, are covered by the state law. So the state law has more protected classes actually than the federal law does. Next slide.
So let's go through a couple examples of discrimination. And the first one would be an example of intentional discrimination. So here, the Yao family has 2 small children, and they apply for a 3rd floor apartment with Lenny, the landlord. Now, Lenny says that they cannot rent to them right now because he has a policy against having kids live in 3rd floor apartments because he thinks it's unsafe. And then he doesn't have any other apartments available. This would be a discrimination against the Yao family based on familial status and would be a fair housing violation. Lenny cannot treat the Yao family differently from other tenants simply because they have children. He has his own opinions about where kids should be allowed to live.
So here's an example of a disparate impact violation of the Fair Housing Act. So Lenny, the landlord, has a policy that he will not rent to anyone who doesn't have a full-time job. Sam, who's a retired disabled veteran who has enough disability income and savings to afford the apartment, applies, but Lenny denies his application, citing his policy that tenants must have a full-time job to rent his apartments. So Lenny's policy not to rent to applicants who lack a full-time job disproportionately affects disabled applicants, which would be like the federal law, as well as elderly and former military applicants and their source of income under the Virginia law. So that's an example of a facially neutral policy that has a disparate impact on a protected class.
And lastly, as an example of a failure to make a reasonable accommodation. So Janet is visually impaired and she needs the assistance of a seeing eye dog to get around. Janet applies for an apartment with Lenny, the landlord. However, Lenny has a really strict no pet policy and refuses to rent to Janet, or if he says, I'll rent to you, but you can't have your dog. Janet asked for an exception to the no pet policy because she needs her seeing eye dog to get around. And Lenny refuses to modify that policy or grant her an exception. This would be an example of Lenny discriminating against Janet based on her disability and would be a fair housing violation.
And both the state and state and federal fair housing laws protect against retaliation against an individual who's made a fair housing complaint, filed a fair housing lawsuit, has testified in any kind of fair housing proceedings, or otherwise assisting them. So it's a separate violation of the Fair Housing Act. And it doesn't depend on either the success of the claim of discrimination or the person's, being in a protected class. It's a general prohibition against retaliation that covers everybody. And here are some examples of retaliatory conduct: threatening to report a person to the police or to ICE, the immigration authorities, threatening to evict a person, increasing their rent, or decreasing services to the apartment. But a landlord can evict. This is not retaliation if the tenant is behind on their rent, if a tenant has stayed beyond the term of their lease. A landlord can increase rent to market rate, but the circumstances around that is what you should still look at, because that could still be a form of retaliation. And decreasing services to everyone. So if a landlord decides suddenly, oh, we're not going to include utilities in the rent anymore, and applies it to everyone, that would not be a form of retaliation.
So now to get in some specifics. So Virginia passed a added source of funds to our Fair Housing Act back in 2020. So as of July 2020, these protections are in place. So what does source of funds means? It's referring to any source that lawfully provides funds to or on behalf of a renter or buyer of housing. And this can include any form of assistance, such as a housing voucher, some sort of benefit, if someone is receiving like down payment assistance or some sort of subsidy program. And this applies whether the program is administered by a government or non-governmental entity. So it could include if a nonprofit is, helping to pay security deposit for a prospective tenant. The landlord cannot discriminate simply because that money is coming from that nonprofit. And so the types of source of funds discrimination, and this is not exhaustive, but some of the main ones would be refusing to rent or sell based on someone's source of funds, imposing, hold on, I'm going to pause for a minute because there's a fire truck. My apologies. So it would be refusing to sell or rent to someone based on how that person is paying the rent, where that rent money is coming from. It could include imposing different terms or conditions or privileges. For example, they say like, sure, we'll accept voucher holders, but you're not allowed to use the pool. That would be a violation. Or if they put advertisements out that say that they're not going to rent to voucher holders, or giving some sort of preference or limitations based on that source of funds. Or something that we still see frequently despite these protections is telling a prospective tenant that that unit is unavailable, even if it is, simply because that person has a voucher. So there are some exemptions to this, but the burden of proving whether this exemption applies is on the person who is asserting the exemption. So if a landlord says, well, this doesn't apply to me, that landlord has to prove that the exemption applies. So who does the exemption go to? It applies to landlords who own 4 or fewer units. They can deny or limit the occupancy of a person because of source of funds. Now, it does not apply if the landlord owns a 10% interest in more than 4 units. So this is just making sure if you have, a company that has interest, a little bit of interest in a whole bunch of different apartment complexes, they're not allowed to try to escape under this exemption here. It's really meant to protect small mom and pop landlords. And secondly, and is one that could be a problem for some people who have a voucher, a landlord can deny or limit occupancy based on source of funds if those funds are not approved within 15 days of that tenant's request for approval. This is getting specifically at those who are trying to get some sort of subsidy or voucher. And some of the technical language here is that request for approval is referring to when approval package from a voucher administrator is in the mailed, emailed, or delivered. That's the request for approval. What happens typically with any sort of voucher is once they get approval or initial approval, they have the housing authority will do an inspection of the unit. And if that inspection isn't completed and they have final approval of the unit within 15 days, then the landlord can back out and refuse to rent to the tenant. However, that landlord has to participate in good faith. They can't set up unreasonable barriers such as being slow in getting their part of the paperwork together, or denying access to people to actually do the inspection. They can't, use backdoor methods to skirt around and try to stretch out that time for approval. And so what does source of funds discrimination look like? So here's an example. Michelle lost her job during the pandemic and she is struggling to keep up on rent. So she applies for the Virginia Rent Relief Program to cover the next 3 months of rent. Michelle's landlord, Lenny, he owns 8 units, so he doesn't fall under that exception. However, he refuses to cooperate in completing that rental application, insisting that he doesn't participate in government programs. Nonetheless, with the help of a rent relief navigator, Michelle is able to complete a rent relief application without Lenny's involvement. However, when the check arrives, Lenny refuses to accept the money. Lenny has violated source of funds protections in 2 ways. One, he refused to cooperate with that rent relief program in the first place. And secondly, he refused to accept the money from the rent relief program. And that would be a clear example of source of funds discrimination. And the next example is probably one that we can continue to see the most with voucher holders. Here, Lenny, the landlord, requires all tenants, regardless of where their rent comes from, to have income that is 3 times the monthly rent amount. Here, the monthly rent is $1,000. Therefore, Lenny is requiring tenants to earn at least $3,000 a month. Now, Alice, she makes $800 a month, and she has a housing choice voucher so that she will only have to use 30% of her income towards rent, which is $240, and her voucher will cover the remaining $760 of the rent. However, when Lenny is determining whether Alice meets those income requirements, he adds Alice's income, the $800, to the voucher amount, which is $760, to say that she has an income of $1,560. And because Alice doesn't earn 3 times the rent, he refuses to rent to her. This particular method of calculating income discriminates against voucher holders and would be a source of funds discrimination. Landlords should not be counting the voucher as income because it's not. That voucher is going directly to the landlord to pay for the rent. They should only be assessing how much income Alice is required to earn based on her portion of the rent that she's paying. So if Lenny is going to correctly calculate her income, he should be doing it 3 times on the amount of rent that she's going to be responsible for. So since she's only going to be paying $240 towards rent, that's the amount that she's responsible for. She should only have to earn 3 times the amount of $240. I know that's kind of confusing, so if you have any questions about that particular piece, feel free to reach out. So Virginia, the Fair Housing Board has some really great guidance, particularly when it comes to the source of funds discrimination, how to properly count, income requirements and such as this, so that if you have a tenant who is finally got a voucher, trying to get approved, but the landlord is saying they don't earn enough money, this would be something to take a look at.
So I'm going to go into some common issues that various service providers may run into depending on the type of service that they do. So I'm going to cover about 4 different areas. So the first area is for victims of domestic violence. Domestic violence victims are not a separate protected class under either the Virginia or the Federal Fair Housing Act. However, most domestic violence victims can claim protection as a form of sex discrimination in housing. but there may be other protected classes that could come into play, including race, color, national origin, disability, or familial status. And there's a separate federal law that provides additional protections to victims of sexual assault, dating violence, and stalking for residents in federally subsidized housing. I'm not going to go into what that is, but I just wanted to at least point out that there is, some additional protection specifically geared towards victims of domestic violence. Next slide. So here's some examples of what discrimination might look like against domestic violence victims. First, refusing to rent or negotiate a rental or a sale because the person is a domestic violence victim. Second, evicting a domestic violence victim because the abuser damaged the landlord's property. Another is a landlord's refusing to make repairs or provide proper maintenance because a tenant is a repeated victim of domestic violence. In other words, a landlord saying, I'm not coming back here to fix this again after you got assaulted by your abuser. All of those would be potential fair housing violations. Next slide. Another common issue for service providers is dealing with clients who have mental health issues. And those individuals would be protected under both the federal and state fair housing laws on the basis of disability. However, there's no protection for persons who pose a clear and present threat of harming others or harming the property itself. And that's something that has to be based on an individualized basis. In other words, a landlord can't say, oh, you're a schizophrenic, you're gonna hurt people, and I'm not gonna rent to you. That's not gonna cut it. It has to be based on the person's actual history of potential of harming others or destroying property. And there, again, as in the domestic violence sphere, there are other federal laws that also apply here. One being Section 504 of the Rehabilitation Act, which bans recipients of federal funds from discriminating on the basis of disability. And the American with Disabilities Act is more of a opening up public spaces to make sure that they're accessible to people with disabilities. Next slide. So here are some examples of unlawful discrimination against persons with mental disabilities. Again, refusing to rent or negotiate a rental or a sale because the buyer or renter has mental health issues. Charging a person more in rent or a higher security deposit because of their mental health status. Using stricter criteria or asking questions about a person's mental health treatment or medications. That's all supposed to be private information. So that too could be a fair housing violation. And lastly, refusing to grant a reasonable accommodation that would enable a person with mental health issues to have an equal opportunity to use their housing. Again, the example that we provided earlier, accommodating a person's disability with an emotional supportive, an emotional assistive animal. So in other words, if a client of yours has a disability, a mental health disability that is made better by them having a pet, that is the type of reasonable accommodation that a mental health client would be entitled to. Next slide. Another common issue is that service providers may have is with trying to house formerly incarcerated persons. So it's important to look at the housing providers' admission policies and practices. and they may violate the Fair Housing Act if the policy has a disparate impact on individuals because of a particular race, color, or other protected class. And the policy does not serve a substantial, legitimate, non-discriminatory interest of the housing provider, or such interest could be served by another practice that has a less discriminatory effect. So this area of law, I would really highly recommend that you refer them also for legal assistance, because this is more of a cutting edge issue. And the next slide will sort of explain, a little bit why that is. So here are some practices of housing providers that should raise a red flag. That doesn't necessarily mean they're illegal, but these are things that if you learn about a client of yours experiencing, it may, make sense to refer them for legal assistance. So a housing provider's use of tenant screening companies that provide background checks that are often inaccurate or incomplete, or the actual check has no relationship to whether someone will be a good tenant. A related issue of practice would be the use of third-party companies to independently screen and reject applicants using algorithms that may contain racial or other prohibited bias in their design. This is something that you may not easily, learn about. I mean, your client probably won't know, but there may be information that you receive that suggests that may be happening. And then lastly, housing providers informing potential tenants that they do not rent to people with criminal records, thus deterring people with any criminal involvement from applying for housing. Now here, just because a landlord says, I'm not renting to people with criminal records, the analysis still has to go through that three-step analysis that I mentioned in the prior slide. Disparate impact being one of them, and thus it's important to get demographic information about the housing providers, tenants, to sort of get an understanding as to whether there may be some unlawful discrimination going on. This is one of the reasons why I would suggest making referrals to legal for legal assistance for people in this category. Next slide. And then lastly, substandard housing conditions. Usually that problem is not addressed by the Fair Housing Act. It would really be something that's more likely to be addressed under the Virginia Residential Landlord and Tenant Act. There are remedies that tenants can use to force their landlords to make a repair. But it can also be a fair housing issue if the substandard conditions affect the chronic health problem of a tenant, such as asthma, a tenant with asthma being affected by the presence of mold or vermin. And to make out a case, you're going to need to get at least a doctor's letter that connects the substandard housing conditions to their patient's health. Here again, having legal assistance would make a lot of sense as opposed to doing administrative complaints, which we're going to cover in the next part of our presentation. Muted.
My apologies. So if you have a person you're working with and there's some red flags that were raised on what's happening with them based on a lot of this information we shared, what do you do about it? And so that gets into how you enforce a person's fair housing rights. And just some useful tips for people to do is for that tenant or home buyer or whoever to keep a record of instances of discrimination. writing down what happened and making sure to include as many details as possible, including the names of the person who may have made discriminatory statements or who, rejected their tenant application, dates, addresses, if it has to do with terms in a lease, making sure you have a copy of that lease and other details about that interaction. And of course, keep all documents related to it. For example, if you help, you're a doctor and you've, reviewed a patient who has chronic asthma and it seems like it's connected to the mold, making sure they have a copy of those medical records. Also keep all communications with the housing provider, emails, text messages, photos, recordings if possible, and get all those documents together, and then you can contact a fair housing testing organization. So the role of testers can be really helpful in uncovering fair housing discrimination. The way it works is they'll pose as renters or borrowers or patrons who have characteristics of someone who is different than a person who might be a victim of discrimination, as a way to gather information to show that that victim was treated less favorably. For example, if there's been reports about a landlord who has been telling voucher holders that they don't have any apartments available, well, you can have someone else call as just, someone applying for apartment and they do not have a voucher, and that landlord tells them like, oh yes, we have 5 units available for you to choose from. That would be evidence that that landlord has discriminated against the voucher holders. And so it can be helpful to uncover, discriminatory practice generally. And there are a few different organizations that do testing. One here in Virginia is Housing Opportunities Made Equal. They have an office in Richmond, but they're a statewide organization. I know they've been doing some testing in Eastern Virginia recently. So if you're seeing issues that might be larger than one person you're assisting, I would definitely reach out to them. There's also a Human Housing Rights Initiative that does testing. I think they're based out of New York, but they test all over the country, and you can find their websites there.
One additional point I'd like to make about testing is that your social service agencies may want to do it too. So, for example, if you're dealing with a client who has a mental health problem and is trying to get an apartment, you could send other members of your organization staff out who don't have a mental health problem to see if they're treated differently. So you don't need to necessarily go to a professional testing organization. They can be done really by anybody. But the important thing is to make sure that very good notes are taken, and that the differences in characteristics are well documented. Okay, so how is the Fair Housing Act enforced? Well, there are 2 ways, really. One is by filing an administrative complaint, and that can be done either under the Federal Fair Housing Act by filing a complaint with the U.S. Department of Housing and Urban Development, or if it's a protected class that's only covered under the Virginia Fair Housing Act, that complaint would be filed with the Department of Professional and Occupational Regulation, or DPOR. And the important thing is that the complaint needs to be filed within a year of when the discrimination occurred. Alternatively, a lawsuit could be filed in state or federal court under either the Federal or Virginia Fair Housing Act. But this definitely will require an attorney to do that. Next slide. So this is how you can file an administrative complaint. There's an online portal. And we provided the link for that. You can also email a complaint. That's again the email address to use. you could phone in a complaint, or you can mail one to the regional HUD office in Philadelphia. Next slide. And you can file state complaints online. There's the URL and the email address and the mailing address for D4. So the complaint process itself will consist of these 4 basic steps. Intake, which is the receipt of the complaint and the determination that the agency, whether it be HUD or D4, has jurisdiction to hear the complaint, and that it makes out a complaint. So in other words, it's important to make sure that whatever is put in the complaint would be a policy or practice that would clearly be covered by the Fair Housing Act. Once intake is complete and jurisdiction is, determined, the next step is an investigation. This would entail an agency person usually sending a copy of the complaint to the entity who the complaint is against and asking them to make a response. There may be more to it. There may be some sort of fact-finding meeting that's conducted as part of the investigation. And after the investigation is complete, the agency's first role is to try to get the party against whom the complaint has been filed to voluntarily comply with the law and enter into some sort of formal settlement, not informal, formal settlement with the agency. And if that doesn't happen, then there would be further legal action. There may be an actual hearing that's conducted at HUD. It might be conducted by an administrative law judge. I'm not sure who conducts hearings at the state level, but those are the 4 pieces of the complaint process.
Now, I'll add too that these 2 methods for enforcing federal housing, whether it's filing an administrative complaint or a lawsuit, aren't exclusive of one another. So even if you filed an administrative complaint and that person decides, actually, I want to file a lawsuit, there's nothing stopping them from doing that. And it can go the other way. So you've already filed a lawsuit. You can also still file an administrative complaint, even if you've already done the lawsuit. And I actually do recommend that, particularly if you have someone who, is facing an eviction that is based off of, that is discriminatory. For example, if someone's being evicted because of a mental health episode, then you could do a countersuit for fair housing, but I would also recommend filing an administrative complaint and getting it to the Attorney General's office in Virginia to see if they could intercede in the case in any way. Let us know if you have any questions. That was a lot of information we went over, particularly when it comes to what do you do if you have a client or a patron who might have a fair housing violation. You may not be the one, doing that enforcement yourself, but at least you know the process. If someone needs assistance filing an administrative complaint, that's something that Housing Opportunities Made Equal could also help with. But of course, they can also reach out for legal assistance, whether it's with legal aid or someone from the private bar. If you don't have any questions now, you can always feel free to reach out to Steve or myself with our emails here. Ezra will be sharing the slides again if you didn't already get a chance to download it from the chat, as well as putting the video up on YouTube if you have others you want to share it with, or if you want to review it, you are free to do so. Thank you so much.